Right, good afternoon, everybody. It's Maurice Buerta. I want to welcome you back again at the training regarding the grade R contracts. And we will ever also talk a little bit wider than only the grade A R contracts. The reason being for that is because we will only be able to understand the contract determinations and what is included in the contract if we have the broader background regarding grade R. As usually, the PowerPoints will be sent to all member schools in English and Afrikaans, and we will deal with the questions through you using the chat function and then typing your question. I assume there will be time available at the end so that we can answer the most of the questions. Should we however not be able to answer all questions, we will alternatively answer it via email to the people specifically for that. I hope you're going to enjoy the session with us. And grade R it's quite a situation leading to various conflicts at various schools due to the fact that it's very lot of gray areas in the grade R. To explain that to you, I have to go back to the history of the introduction of grade R sites and practitioners and the whole grade R regulations that was published in 2016. And it was also announced in Parliament that grade R will be part of the formal grades of the foundation phase. However, there is still a huge vacuum in legislation by not having it completed, enforced as a grade, official grade at the schools. There are also various schools that don't have grade R classes at this stage, and that should be compulsory should it take place. However, if I say that to you, we've got to bear in mind that if we accept there's 1 million learners per grade, more or less, then you have to add 1 million learners to all schools in South Africa. And that would we will need to build about 29,000 classrooms and appoint 29,000 educators. And if you look at 29,000 classrooms, it's the equal of 1,000 schools. So to achieve that over a short term, it will be impossible. And I don't think the government would have enough money for only for salaries, 580 million a year additional. That's excluding the building of the classrooms. So getting grade R's as totally as part as a formal grade in the school is still a challenge. And that's a political decision that has to be taken, and they have to get the budget for that and build that before they can say, okay, now it is compulsory to have grade R. We do have different groups of grade R centers. We do have on public school premises, we have two types of grade R centers. Those that are managed by the school themselves, meaning that it is a phase of a class additional to the school and the school manages everything. However, we have also a lot of schools that rented out classrooms and there's a private individual or entity that runs the grade R's on the school grounds. Nevertheless, doesn't worry which one of these two you have in your school, the principal stays responsible for both. Then we have also grade R centers at independent schools, and then we also have grade R's and in community centers. And for every grade R center, it doesn't matter where it is, you have annually, you have to apply to have a grade R site, as it's called, and you can apply, all of these schools mentioned can apply for grade R subsidy, and it will be evaluated by the education department to decide if they're going to supply subsidy. The subsidy is obviously ring-fenced for learner training and support material, for maintenance and for administrative purposes. It is there, and the subsidy cannot be used for salary. A further development is, because of this grey area, is that there was in 2019, coming from the departments after discussion with the ELRC, the Educator Labour Relations Council, where there's currently negotiations going on regarding what are the qualifications that will be recognized and what will the benefits be for the appointees in grade R practitioners positions, what will salaries be, and all of that is still in being negotiated there. However, and I'm going to come back to that later, there is one benefit that's been granted very recently. It is that grade R practitioners does have paid maternity leave, and a replacement grade R practitioner can be appointed by the school. However, you've got to apply to the department for this position, and that would then only be a temporary position while the regional educator or grade R practitioner is on maternity leave, who can return to that then. So that's one benefit that's been agreed upon and is already in force. So there's paid maternity leave for grade R. Historically, it has not been there. The other grey area coming of the grade R's is the question, is grade R's then, after the background that I've given you, are they part of the school? And if we answer that question, why is it important to think about this question? Because the question raises questions regarding capacity. If we look at the capacity calculation at public schools at this stage, grade R's are not included in the capacity. So they count the head count from grade 1, that's compulsory schooling, to grade 12, and grade R is not compulsory schooling as such at this stage. And this creates a problem because a lot of schools does have grade R's, but then if they only start counting from grade 1 to 12, then it's determined that the school does have some extra classes available and capacity to place learners in. And we know it's a problem because of Gauteng, we've got 35,000 learners that still has to be placed. So this is a gray area. The next one coming up is exemption from paying school fees. If it's not compulsory, why and how can a parent then apply for exemption of paying grade R school fees? On what basis? Because the grade R center just around the corner, which is run as an independent school, there's nothing like that. You cannot apply for it there. And then also at independent school grade R centers, you can also then apply for that. So that's something to think about. And you will find that in different districts in the education department, they also are confused about this. Our personal opinion is a grade R parent cannot apply for exemption because it's not compulsory schooling yet, number one. It's not part of the school as such. Even the finances has to be run separately for that. So, and the last argument that we have also to give a backup for this is, if grade R learners was part of the school, why would they then have to do an application for admission to be allowed to grade 1? They said they then should be automatically, and I think that's actually fair, that they should automatically be admitted. So it's like a sausage machine effect. If you have enough grade R's, they should actually be able to move on to grade 1 because the child's got expectation. It's already part of the school. So I think it's only fair if that changes in the future that they become part of the school, but then automatically they are part of grade 1. And if you have extra capacity, then people can apply for admission regarding that. But the status currently is grade R's must all apply for admission to all schools. But based on all of those factors, we are of the opinion that grade R's are not part of the school and therefore they cannot apply for exemption, and they're actually a separate entity on the school ground. The annual application also has a great influence specifically on the employment contracts and on annually planning what you're going to do next year with the grade R's, because in June you have to apply to have a grade R site next year, and then you've got to identify the grade R practitioners after the site has been granted and send them in to be appointed. And this is where the situation arises that if I apply for this in terms of the labor relations, and specifically the Labor Relations Act section 198, it says that if a person has to apply annually within a law or a statute, then it can influence the situation of claiming permanent appointment. But I will deal with that a little bit later regarding this. What happens with grade R contracts and why is it differently? It is basically because the Provincial Department of Education pays a stipend. So they pay a specific amount to the grade R practitioner, and then it is the choice of the school, and not the school as such, but the SGB, to pay an additional amount to that stipend. The SGB is not forced to pay an additional amount. It is the prerogative and decision making by the SGB that if they have money available and do they wish to. The stipend actually was increased severely because of negotiations that took place at the LRC, where the government is actually striving to pay a stipend the equal to a post-level 1 salary, less 30%, 37% for the benefits of the permanent appointed departmental educator. So they moved to that point and increased the stipend significantly, and so SGBs has to decide, are we still going to pay over and above that a certain amount? But most of the quintile 4 and 5 schools do pay an additional amount on the stipend. This, however, creates a problem, and I will explain that later to you, and that must be managed by the contract. The second is that the interim arrangement for grade R's stipulates specifically that that's been told that the recognizing the grade R practitioner is an employee of the SGB, and the GDE, for instance, of Gauteng, pays the stipend on behalf of the SGB. So the grade R practitioner is not employed by government. The grade A practitioner is employed in terms of the Basic Conditions of Employment Act as a normal employee of the SGB. And that makes the SGB the employer with employer rights. And should the employee want to raise any difficulties, questions, grievances, whatever it might be, they will have to go through the SGB. The department is not part of that specifically then. And if we look at the additional earning then of that is the SGB's decision based on the contract. Are we going to utilize grade R practitioners for extra co-curricular activities or extracurricular activities? The co-curricular is curriculum activities, additional after the grade R day has gone past, and we want to do additional classes, enrichment education, remediation of certain problems of learners to assist them to perform better, to understand better, while extracurricular went to the culture activities and sport activities. And that's where the SGB has to make a decision and say, we want this person not only to be an educator in the grade R or a practitioner there, we want this person also to do after-hour duties. And then we will have to include it in the contract and also specifically in the job description, what is there. And that leads me to the last point in this slide, that there's different job descriptions depending on what do we want grade R practitioners to do. In certain schools, grade R practitioners are released 1 o'clock, 2 o'clock in the afternoon, they can go home. However, at other schools, it is required from them to give extra classes and to be involved in sport coaching, and that they even have to work on Saturdays in sports. So the grade R practitioner has the choice to apply at various schools, and the grade R practitioner must then make a decision according to the payment received, the job description, and the contract offered, which school is the better one for me. But that is a situation that must be negotiated between SGB and then also with the individual employee. But there is no rule that states grade R practitioners does not have to be involved in that. That's not, because we bumped into problems with schools where grade R practitioners basically just said, we're not going to get involved in any way. Furthermore, if we look at common questions, then a maternity leave, I said, they qualify for paid maternity leave now, and a replacement can be appointed, and I think that's a very positive step that has been taken by the government. What must or may a grade R employee earn monthly? And I've just started to address that previously by saying that, yes, depending on the job description, the contract offered by the school, it can be purely just a stipend, or if the grade R practitioner is going to be involved in a lot of other activities later during the school day, it can be that the HGB can offer as additional payment to the stipend because the HGB is the employer. However, we must note that UIF must be deducted from the stipend. Normal government employees don't pay UIF. Grade R practitioners, the PASOL system is basically adjusted to it that they have to pay UIF. That is also a clear signal that they are not employed by government. So, because government employees don't pay UIF. Then the tax laws is also applicable to grade R's. On the payment is received as a stipend and on the payment received from the SGB. That causes problems at a later stage, and I'll discuss that. What about bonus payment, 13th payments? You will see that the stipends does not include a bonus payment or 13th check, as it's well known also. So that's not included in the stipend. And now it is the SGB, because it's a discretionary decision, that the SGB has to make a decision. Are we going to include a 13th check? Are we going to include it in the in the contract of appointment or not? It cannot be enforced. But this creates lots of problems due to the fact that grade R practitioners, for example, are earning 20,000 Rand a month, 16 from the government, 4 from the SGB, and then when we get to December, then this SGB only decides to pay the 4,000, and suddenly the 13th check or the bonus is only 4,000. There's nothing wrong. It is the decision of the SGB. In fact, it's again not compulsory, but we have to look at the contract specifically, stipulating, are we going to pay 13th checks? And what will the amount? Will it be the equal amount to stipend plus SGB part, or are we only going to pay a 13th check on the SGB, or are we not going to pay a 13th check at all? That is the SGB's decision that they must take regarding this. Common problems we have with grade R contracts, furthermore, is increase in stipends by the department without notice to the governing body. And also the school is not notified in time. So what happens now, if we give the person a contract and we identify the salary will be 20,000 and it's compiled from a stipend plus the SGB, but we are not specific about what's the gross salary, the stipend increases. And then what happened very recently is that you get grade R practitioners due to a huge SGB payment that they're earning 31 to 32,000, more than a lot of senior staff members employed by the government. And the proposed interim arrangement actually states that a grade R practitioner should not be able to earn more money than what the basic introduction level of a department post level 1 person would be. So this is the big problem regarding grade R contracts that we're bumping in, and that's where we say the contracts must be adjusted and it must state a gross salary. So the grade R practitioner must agree to a grade R gross salary, and the gross salary will be made up of the stipend and a contribution of the SGB. Should, however, then the stipend increase, the SGB, right, will have to pay lesser, contribute lesser to get to the gross salary. But most schools are in a difficult situation because the contracts did not state that. And with the increase in the stipends, it was substantially increased in the last year, brought it to fore that these grade R practitioners had huge salary increases, And it's not that I'm saying they should not get it, but we have to look at the school finances responsibility and ask, should we then pay over and above for the school still the agreed amount that we have? So the contracts has to be revisited on that. And flowing from that, it also boils down that if the department increases the stipends, there's a lot of back pay that's given. And the question is now, should the grade R practitioner pay that back or not? It depends on your contract. And that's where we say, if the contract is formulated correctly by stating this is the amount grossly earned, so that if you get more stipend, you get back pay, then we must adjust your salary from when the increase was initiated by the department so that we can do this. This is getting a huge difficulty from schools, grade R practitioners refusing to pay back because they fall back on the contractual determination, and then they're 100% correct. But on the other side, the school stands there and says, but listen here, we are paying, we had the idea of paying you X as a gross salary, and the stipend was increased, and now you're earning much more than that, and the school has to save money, especially with the influence of COVID these days, and we have to work very carefully with parents' money. So we have to go and look at the contracts, and our member schools have a grade R contract available that fulfills all these requirements. And in our contract, it says that there will be a gross salary, and should the stipend from the Gauteng department increase, the supplement amount by the employer will decrease automatically. We stipulated that in the contract, and that's essential that you have to put that in. And then furthermore, should the Department of Gauteng or any education increase the stipend amount included, and the employer does not have knowledge about that, the repayment of that excess amount must be paid back to the employer, and that is then the SGB. I think it's only fair to have this, but if you don't have this, you won't have a standing regarding to claim it back from these grade R practitioners because of the lack in the effectiveness of your contract. So keeping that in mind, contracts of grade R's does look different from normal SGB staff. We cannot just use normal SGB staff contracts for that, because then we are going to bump into these problems. And then we must also make a decision in the contract, and that's the last comment on this, is that grade R, are we going to stay open during holidays or not? Because a lot of them are linked to nursery schools. A lot of them are on school grounds, but parents don't have other choice. And that parents at additional fund might request to send children to the school during the school holiday. This can be arranged, but then it must form part of the job description. And I think additional payment will have to be necessitated there, because the other educators will have leave and holiday, which the grade R practitioners won't have at that stage. So this is the most important changes regarding the contract of that. Then the question that came up that we bumped in and said, should the SGB apply in terms of South African Schools Act Section 38 for approval of additional payment, meaning the stipend plus the additional payment? No, it's for sure not that there's Section 38A needed for that, because the proposed interim arrangements that was put in place says that the practitioner is an employee of the SGB, not of the GDE. The written contract is between the SGB and the grade R practitioner. So it does not fall within the ambit of Section 38A. It has been applied differently in different districts, and district offices has different opinions about that. But let's go back to the law. Section 38A only applies to people employed in the public service by government. And it's purely because the contract states this person is employed by the SGB. So Section 38 applications is not needed. Will the department appoint a replacement for grade R practitioner on maternity? Yes, I've already said that, but there's a link to this. What happens if you go on maternity leave for November and December, and your contract expires on 31 December, are you still going to be entitled to payment for January and February because your contract is not anymore in place? And that is a gray area. And we believe you would not qualify for maternity leave benefits because you're not in service of the SGB anymore. And the stipend is paid to the school on the basis of 12 months. The stipend is not automatically carried over. If we can refer back, I say to you, the school has to apply every year for grade R site and grade R practitioners. And that's an annual contract that is concluded between the grade R practitioner and the SGB. And then it expires on 31 December, but you're still on maternity leave in January. I don't think you are entitled to get a payment there. That is something that the ELRC will have to look at. And that brings us then to the next question. Can the grade R practitioner demand permanent appointment when the contract is renewed? Now, this is forthcoming from Section 198 of the Labour Relations Act, 66 of 95 as amended. And 198 says, if you earn lesser than 211,500 and a couple of rands, if you earn less than that per year, you actually become permanently employed after 3 months. And if you earn more than 211,500 and a couple of rands per annum, then after 1 year, if the contract is renewed, you become permanently. So a lot of grade R practitioners and even schools and SGBs are under the impression that, yes, I can claim permanent appointment due to this. However, 198 also says a little bit later in the section of the Act says that if this position has to be approved annually and applied for within a statute or within legislation, you don't fall under this determination. So the bottom line of that, and we are involved in a major case at this stage where we will clear the air around this and communicate this to schools of what is the legal standing on that, because there are 2 schools regarding that. One school says, yes, they are permanently appointed. They recall 198. The other school also recalls 198, but says, but on an annual basis, you have to apply to get this position approved. So there's merits in both cases, and we will have to clarify this, and this will be communicated on the outcome after we had the hearing regarding this issue between a SGB and a school, because I think that will give us a guideline of what will the future be. Can the person then be demanding a permanent appointment or not? Our current viewpoint is no, you cannot claim permanent appointment due to the reasons as explained to you. Can grade R practitioners be involved in co-curricular, that's curriculum activities after hours or extra activities at the school? Yes, they can. It depends on the SGB. Does the SGB need them? Is it written into their contracts? And is it part of their job description? And if it is, yes, then you can require them to participate or deliver their services as other educators do. But still, there has to be an agreement in terms of a contract and a job description. And if you want to introduce it now, after that, the grade R people has been employed, the practitioners have been employed for a certain time, I think you will have to renegotiate everything and be fair and first consult about that and give the reasoning for that. Why do we want to do it? I think it cannot be unilaterally done in the term of contract, but when a new contract is offered, obviously, yes, you can. And it's also the SGB's decision to determine we are going to pay more money or we're going to increase the additional amount above the stipend or not. We must just bear in mind the quintile 1, 2, and 3 schools that are no fee paying schools, their grade R practitioners only there gets the stipend. They don't get additional money. They work for the stipend, but in those schools, the majority of them, most probably the grade R practitioners, will not be involved in co-curricular or extra activities at school after hours. The next one is, can the principal require grade R practitioners to work after hours, for example, at parent evenings? The answer to that again says, yes, it can, because I see it's part of the performance of the curriculum activities that's got to be formed. And remember, the principal is in charge, even if the school is run by a private entity on a public school ground, the principal is responsible for everything that happens there. However, he cannot intervene into the employment relationship between the employer and employee because they're not there, but he's got to see that the school is functioning well and fulfill all norms and standards there. So the principal will obviously also look at the relationship between parents and children and decide what is in the best interest of children. So yes, I think grade R practitioners can. We bumped into a couple of situations where they refused to do that. However, it was very limited, but to secure yourself, I think you must write it into your contract and also as part of the job description. Obviously, in the discussions that we had so far, is the question can then come up, but who can discipline or reprimand then a grade R practitioner? Obviously, it will be the principal in public schools environment where the public schools are running it, that they can do that. But when it's run by a private entity on school grounds, it will be the private entity that will have to have a code of conduct and will have to have a grievance and disciplinary procedure as part of the employment contract. The part of the disciplinary and disciplinary grievance procedure should also be part of the contract for grade R practitioners employed on school grounds under the management of the school. That's actually a non-negotiable. It should be in place that it is in place that should the person be reprimanded, disciplined, that there are certain rules to the game, just to ensure that there are fairness. The ultimate responsibility where the person is employed by a public school SGB is that the SGB will discipline this person. And this now leads to a problem, because should that grade R practitioner be dismissed, the stipend cannot be ended by the SGB. The SGB will have to write a report and have the necessary HR document completed by the dismissed person. What are we going to happen if the dismissed person then refuses to sign it? We will have to put an affidavit in and write a motivation to stop the stipend to the department. And then the department obviously I imagine will have to investigate the matter, because to cover themselves by stopping the stipend, they will have to have a valid reason for that. So they will have to also look into the matter, although the SGB has the right, or if it's a private entity, yes, the private entity can, but if you claim subsidy from the department, that subsidy will also have to be stopped paying to that person that's dismissed and maybe carried over to a next grade R practitioner, but you would have to inform the department regarding the change of the person who's going to receive the payout. Must grade R practitioners pay UIF and income tax? Yes, they do have to do that. And the problem that we're bumping in here is, in the PASHAL system, tax is deducted of the amount paid as a stipend. And then the SGB pays a person, and they also on some other payroll that the school uses, and they also deduct tax. But coming to the end of the tax year, then the grade R practitioners bumps into a huge problem. Why? Because if you take it the amount that the PASHAL system deducts, it's lesser, even combined with the SGB tax deducted, it's lesser than what it should have been on the total gross amount that's paid over to this person. So if you look at that specifically, that's why grade R practitioners receives huge tax assessments at the end of a tax year, and then they have got to pay in. Because of this reason, that tax is not enough deducted from it. While if we write into the contracts that we will use the tax scale of deduction on the gross salary paid by the stipend and the SGB, then the grade R practitioners might have lesser money every month, but at least they will be sure that they're not going to get a surprise at the end of the tax year. Is it a requirement that a grade R practitioner must better qualifications to RQV 13? Yes, it is. It is. And that's the long-term strategy regarding the interim arrangement and picking up salaries, because the people who receive the stipend increases are those people with the necessary qualifications. And grade R practitioners will have to get themselves up to date of which qualifications are recognized and which are not. Because I can foresee, and let's just use an example, don't quote me as I've said it will be, but say, for example, that the government decides in 2024 that all grade R's, it's now compulsory, and grade R practitioners will be absorbed as educators. Then in terms of the Employment of Educators Act, you will have to have a qualification, a professional education qualification, and a valid SACE certificate. So obviously, then if you want to be absorbed, I think for the interim now, all grade R practitioners should be motivated to better their qualifications to such a level that they can qualify to be appointed as specifically professional qualified educators. That's going to solve a lot of problems when we move into the transition of grade R becoming compulsory as part of the foundation phase in schools. So this is grade R practitioners must pay attention to this. And you can also look at the document came out in 2019, specifically for the interim arrangement, where it is very discussed in depth of which qualifications is recognized, which not, and what is the idea, what is the strategy that we are moving towards for this coming, I say example 2024, we don't know what it is because I mentioned to you the huge amounts payable specifically by the state for salaries and for infrastructure and classes and to get all of that going. The next question is, can ECD qualified practitioners continue to educate pre-grade R learners? Yes, for sure. ECD people can train the pre-grade R learners at any time. However, in grade R, because grade R has now got a CAPS curriculum that's got to be performed, we, however, prefer rather to have qualified educators doing the education there. And I know a lot of ECD qualified practitioners currently is in the process busy to obtain their professional qualifications. And I think for the interim, yes, they can stay in the classes, but like stating, in future, they will have to become qualified educators through a SACE and a recognized professional education qualification. Does the school apply annually to have a grade R site and practitioners to be appointed? Yes. And going back to section 198 of the Act, that is the viewpoint what we have, that we say, due to the fact that annually you have to apply for that, there's no chance that you can claim to be permanently appointed if you're a grade R practitioner. And like I said, we will deal the outcome of the legal process involved here, where we are part and role of, that we will give feedback to the schools regarding that. If our opinion was wrong and the other party was correct, because the other party believe you can demand permanent appointment. Must grade R practitioners attend departmental training? Yes. All grade R people who receive a stipend or are part of a subsidized grade R center, you don't have a choice. You have to attend all departmental training where grade R practitioners are invited to, because they do discuss the CAPS curriculum, and maybe you should attend it also to know what is the strategy of the future and what is the current problems dealing with. And it is one of those meetings actually that it was made public that they do qualify for paid maternity leave. So a lot of information that might be important for you as a grade R practitioner in individual, a lot of information is shared there. Yes, you can. If you don't receive a stipend and you do not work with a subsidized grade R center, then you don't have to attend departmental training. However, I think it's worthwhile to keep yourself up to date, what is dealt with and what is explained and what the people are trained during these sessions. Should grade R statements be audited financial statement? Yes, it's clearly stipulated in the 2016 regulations that the grade R books should actually be kept separately, where all the income and expenditure must be explained and there must be strict financial controls regarding the finances of grade R center. The question then pops up, if they're not part of the school, may we use school fees to subsidize them if they make a loss? My answer and my opinion is no. The grade R center must be standing on its own legs, and it is an economic, feasible act that the school is tackling on by putting grade R into the school community. That also then leads you then exemption, because if you're going to give exemption for grade R's, then you're going to end up at a situation where that the rest of the school will have to subsidize the grade R center when they make a loss. And that's why we still of the viewpoint that grade R is not part of the school as such at this stage. That is just a further argument to strengthen our viewpoint on this. Important information if we talk finances is that the subsidy received by all schools, public schools or any other grade R center that receives subsidy, and this money may not be used for non-grade R educational purposes. So if you receive the subsidy, you cannot bring it back to the school fund to enhance your school fund again. Grade R monies are grade R monies and must be used for the educational purposes of grade R. And the regulations specifically determine furthermore, the subsidy given to you by the state may not be used to buy property or vehicles. You may not with the subsidy allocated to you. If you receive other monies over and above the subsidy, yes, you will be able to use it for these things. But however, your booking system and your financial statements will have to point out that that money is specifically which is received, the subsidy is used for grade R. Additional funds may be used for anything else. And also, subsidy may not be used to grant loans or repay loans. To grant loans to, for instance, staff members, you cannot use that subsidy to grant loans. And you can also not use it to pay off loans that the grade R center borrowed. And that further points out that the grade R is an independent institution, meaning that if they loan or borrow money from a bank or somebody, that they have to repay it out of their own funds. They cannot do it from subsidized monies, cannot be utilized and used specifically for those purposes. So in the regulations, these three determinations are available there, and you can go and have a look at that. Right, that's more or less what I wanted to deal with you. I think the essence is the grade R contract is a total different contract of all other employed educators on the school ground. We'll have to pay attention specifically in public schools and in private enterprises running on a public school, a grade R center, and even independent schools. We will have to look at the grade R contracts, and there are certain determinations that we will have to include there that are not part and parcel of your normal contract of educators, because this is a specific situation, specifically if we refer to the subsidy received, secondly to the stipend, and thirdly to the additional amount paid by the SGB, and then also specifically on job descriptions and extra activities that is expected to be performed by grade R practitioners. I'm open for questions, and we've looked so far. There's no questions, and if there are no questions, I hope you've enjoyed it. you can contact the MBK team. We are available. And like I said, we have sent our grade R contract that fulfills all these requirements to all our member schools. And if you're from a non-member school, please contact us and let's talk to you and see if we can arrange anything with you. Thank you very much, and I hope you enjoy the rest of your afternoon. Thank you.